blog, and a long-time editor of the Federal Sentencing Report. We welcome you to this hearing for your testimony.
Thank you very much, Mr. Chairman, Mr. Ranking Member, members of the committee. I very much appreciate this opportunity to share my perspective on President George W. Bush's sudden and surprising decision to commute entirely the prison term of Libby. As I will explain, President Bush's commutation was fundamentally a sentencing decision, and a sentencing decision that is peculiar and suspect on its own terms, and a sentencing decision that is inconsistent with the Justice Department's stated sentencing policies, with arguments federal prosecutors make in courts across the nation every day, and with the equal justice principles that Congress has pursued in modern sentencing reforms. Significantly, President Bush's statement in support of the commutation actually praises Mr. Fitzgerald's investigation and prosecution, and also the jury's work in returning convictions. Ultimately, the statement focuses its criticism on U.S. District Judge Reggie Walton's sentencing choices. The President says, quote, "The prison sentence given to Mr. Libby is excessive, and that's why he says he decided to commute the 30-month prison term imposed by Judge Walton." Seeking to justify this decision, the President claims that Mr. Libby is still subject to, quote, "a harsh punishment because the commutation left in place the fine and supervision term ordered by Judge Walton." President Bush's statement also stresses collateral consequences, the damage to Mr. Libby's reputation and his family suffering. I must say, as a student of sentencing, that the stated reasons that President Bush gave for commuting all of Mr. Libby's prison time are somewhat hard to understand and perhaps even harder to justify. Mr. Libby's prison term was set at the bottom of the sentencing range suggested by the federal guidelines created by the U.S. Sentencing Commission. This term was recommended by an experienced prosecutor and selected by an experienced judge. The President's conclusion that Mr. Libby's term was excessive thus contradicts the recommendation of an expert sentencing agency and the determinations of the prosecutor and the judge most familiar with Mr. Libby's criminal offenses and personal circumstances. And quite notably, under existing precedents, the D.C. Circuit Court of Appeals would have considered Mr. Libby's 30-month prison term, and even a longer term set within the guidelines, presumptively reasonable on appeal. Significantly, unlike some other high-profile cases which have led to calls for the President to exercise his clemency power, even by some members of this committee, the prison sentence in Mr. Libby's case was not the product of a mandatory sentencing provision. Judge Walton clearly had discretion to choose whatever term he thought was appropriate under the circumstances, although federal law did require him to impose a sentence he judged sufficient, but not greater than necessary, to achieve the purposes of punishment that Congress has set forth in federal law. Obviously, Judge Walton believed that not only a fine and supervision was necessary, but that the 30-month prison term, again to stress at the bottom of the applicable sentencing range, was sufficient, but not greater than necessary to achieve the punishment goals that Congress has set forth. Of course, defendants and their attorneys often complain that sentences set within guideline ranges are excessive, and they frequently appeal within guideline sentences, claiming that they are unreasonably long. But in thousands of such appeals in recent years, no federal appellate court has declared a single within-guideline sentence to be unreasonably long. Indeed, since the Supreme Court's decision in United States v. Booker, the vast majority of sentences imposed above the guidelines have been declared reasonable by federal circuit courts, and many sentences below the guidelines have been declared by courts unreasonable in light of congressional sentencing purposes and policies. Even if one accepts the President's assertion that a 30-month prison term for Mr. Libby was excessive, it's hard to justify or understand the President's decision to commute Mr. Libby's prison sentence in its entirety. keeping Mr. Libby from having to spend even a single day in prison for convictions that the President in his own statement said were serious and are matters that cut to the heart of our criminal justice system. The Justice Department, in a series of policy advocacy and speeches to this committee and speeches to the Senate, in a variety of testimony, has emphasized the importance of equal justice. Members of this committee and Congress as a whole have often emphasized the need for guidelines to be enforced in a way to ensure that all members of society are treated equally. Candidly, in my own writings, I've been concerned that some of the personal circumstances emphasized by President Bush don't find their way into the application of the guidelines. But I'm particularly concerned that the Bush administration argues every day in court that other persons should not be subject to the compassion that the President showed, obviously, in a statement towards Mr. Libby. I have, in my testimony, detailed in more particular some of the inconsistencies between the goals that Congress has pursued in sentencing reform and the statements made by the President. I'm happy to answer questions about those particulars, and I very much appreciate the chance to testify before this committee. Thank you.